All we needed was
Mr. President, it's been a long debate. Fortunately, it's a short bill. So when we get to committee, it will be quick. A few points in closing. So the first point. The first point that I wish to make, Mr. President, there's been a discussion around what is the nature of the NHT. And I would say, like Senator Knight, in my view, the National Housing Trust is not a trust. If one examines the Act, one sees that the National Trust is simply a statutory body, and it has the same basic structure and characteristics of other statutory bodies. It is a statutory construct. It is not an equitable construct. There's no settlement. There's no declaration of trust. There are no precatory words. There are none of the essential hallmarks of a trust. And Mr. President, the fact that the word trust appears in its name does not mean that it is in law a trust. You can call a dog a duck, but that does not make it a duck. The Heart NTA has the word trust in its name. It's the Human Employment and Resource Training Trust. But it too is just a statutory body, and it's not a trust in the legal sense of the word. The Resolution Trust was the name given to the US equivalent of FinSAC, the agency set up to deal with the failed financial institutions in the US savings and loan crash of the 1980s. That entity was not a trust, although it was called a Resolution Trust. And in the US antitrust laws, which target monopolies and other anti-competitive practices which lessen effective competition in the market, those laws have nothing to do with trust in the legal sense of the word. Similarly, and importantly, Mr. President, if one examines the audited financial statements of the National Housing Trust, you will see that there are no trust assets. The cash contributions, investments, and loans are all on the balance sheet of the National Housing Trust, representing their property. And the trust has statutory obligations, in a general sense, to provide housing solutions in accordance with the policies laid down by the board. And if persons do not receive benefits after 7 years, they're entitled to get back their contributions. And there are adequate resources in the trust to ensure that that will continue going forward. And it's on that basis that I have a clear conscience in supporting this bill. It is because I believe that this is the right thing to do to ensure that we have an IMF program, without which the country would be in a very dark place. And this funding that the trust is going to provide to the Consolidated Fund as revenue is going to ensure that we are able to have an IMF program and start to get our debt under control. There was a point raised, I think, by Senator Malahoo Fort, and I think Senator Johnson Smith joined in that point, questioning whether the legal advice received by the government that these funds could be taken from the NHT, relying on the powers created by the Public Bodies Management and Accountability Act, was correct. And they were saying that those powers had to be read subject to the NHT Act and the way that act is structured. But you know, the fact of the matter is that that is based, I believe, on a misunderstanding of the Public Bodies Management and Accountability Act. And I'm going to quote a statement of Hansard here, where the former Senate, actually, the previous government, where the current leader of opposition business in the Senate was presenting. And of course, present were Senator Tavares Finson, and Senator Malahoo Fort was there, and indeed, so was I and some other persons. And Senator Arthur Williams is recorded as saying, in relation, and this was on the debate relating to the amendments to the Public Bodies and Management Accountability Act to provide for the ability of central government to have access to resources from those bodies. And the record says as follows: on the matter of conflict between the Companies Act and the PBMA Act, I just want to remind the Senate and Senator Golding, who made the point, that the PBMA Act has supremacy in relation to any other law in respect of the provisions of this Act. You will recall that there was an amendment to the supremacy provision in Section 27, which is at Clause 23 of the current bill, giving supremacy to this law in relation to any other in respect of public bodies. So,
point of information, Mr. President.
Yeah.
Am I now the authority on this matter?
and Mr. President, Senator Williams asked whether he's the authority. He's not the sole authority, because I'm also going to quote from somebody who I don't think I've ever quoted from before, but I'm not sure if I ever will again. But on this particular occasion, I agree with what he's saying, and he's not other than the former Minister of Finance, Mr. Audley Shaw. When in the House of Representatives on the 7th day of June 2011, he said the following, and it's a similar point. He said, quote, this, and I'm quoting from Hansard, this clause, which will be renumbered as Clause 23, proposes general supremacy for the PBMA in relation to the operation of any public body. The proposed clause is a replacement of Section 27 of the Principal Act, and the general supremacy provision would remove the possibility of ambiguity or uncertainty regarding the interpretation and application of the PBMA Act and its status versus the constituent laws of statutory bodies and the Companies Act. So, Mr. Chairman, Mr. President, that was the purpose for which the PBMA was amended. And it is on the basis of that that the legal advice was given. And I also want to... The reason why we now have this bill before us, as I said in my opening, is because of the circumstances which arose after the announcement of this particular positive initiative, where the board of the IMF is yet to finally determine whether or not they accept the agreement. Litigation was commenced by this body called CAPI, and it was felt appropriate, prudent, and in the interest of good governance to put the matter beyond peradventure by a specific amendment to the NHT Act, and that is what has taken place. I would also mention, Mr. President, that it was the policy of the previous government to contemplate distributions from the NHT. I have here a copy of a letter of December 6, 2010 from the Ministry of Finance and the Public Service, as it was called under the previous government, addressed to the then chairman of the National Housing Trust, Mr. Howard Mitchell, and which, in the discussion of the amendments to the PBMA Act, the person writing on behalf of the Financial Secretary made the point that the PBMA Act was amended in March 2010 and became effective on October 1 following. Public bodies are asked to apprise themselves of these changes and to take account of the implications for the corporate plan and budgets. Another slate of amendments is underway and is expected to be presented to the Parliament before the end of the 2010-11 financial year. The Ministry proposed, and it goes on to say, the drafting of regulations to the...
Point of order.
Yes.
What's the point of order,
if
Senator?
the Minister is not abusing the opportunity which has been now given to him to wrap up the debate. He is introducing new matters into the debate. He is introducing contention into a debate that has been going so well. Now to be bringing in at this late stage correspondence between the Minister of Finance and the NHT is not quite correct. As I understand that he should now be summing up the debate, moving into committee and asking for our support, not introducing new matters of contention and contentious nature.
Senator, The minister is in his right to respond. To issues raised, and I believe that he's doing so.
You know,
Point of order is not
With the
accepted.
greatest of respect to my colleagues, it is perhaps ungracious to applaud the ruling of the president.
The letter continues, the letter to the NHT from the Ministry of Finance and Public Service, as it then was, continues. The drafting of regulations to the Act, including the financial distribution policy, is still incomplete. This is back in 2010. Notwithstanding, public bodies are being directed to provide for a minimum distribution of 5 to 10% of surplus to the Accountant General from surpluses over the 3-year planning period. So, Mr. President, that's a letter from Finance under the previous government to the NHT contemplating distributions being authorized under the Public Bodies Management and Accountability Act, which was then being amended for the specific purpose of allowing the surplus to be used for general budgetary purposes and to be taken as revenue. And that is the basis upon which the advice was given, and I've explained why it was that the decision was then taken. It was good.
It was good for the goose.
Mr. President, there was a reference, I think Senator Johnson Smith quoted from Michael Manley. I believe it was in 1976, that debate? Yes. Yeah. It's quite clear, Mr. President, that Mr. Manley at the time was giving a high-level description of his aspirations for this new body that he had conceptualized.
Senators, you have all had the opportunity. Please allow the minister to conclude the debate. Thank you.
Saying with the greatest of respect on a point of order, he should be given an opportunity to conclude the debate, not introduce new and extraneous matters that were looked at before. And I resent the fact that the minister feels that he is in a position to quote Michael Manley.
Senator, there's no limitation. Senator, you know quite well, Senator Tavares Finson, you know quite well that there's no limitation on what the minister can present as long as it is relevant to the subject.
No. Point of order. Point of order. When the president addresses a member, the member should sit. And I would expect a member who has been here perhaps for as long as the Senate been in existence, you should know that.
Thank you, Mr. President. I'm simply addressing issues that came out of the presentations made by the senators earlier, which is my role as wrapping up the discussion. I was making the point that Mr. Manley was giving he was quoted extensively by Senator Johnson Smith. She drew for Hansard and quoted him extensively. And I'm making the point that he was giving what I would say could be described as a high-level description of his aspirations for this new body which he had envisioned and which was about to be created. His was not a detailed legal textual analysis of the structure of the new body, and to ascribe any more significance to it than that, I think, is thus misplaced. Mr. President, the point should be made as well that the legislation that we are being asked to pass contemplates payments of up to 11.4 billion per annum. It doesn't necessarily mean that in each of the 4 years that amount will be fully drawn. It will depend on the overall performance of the economy and tax collections and expenditure levels and so on. But it could be less, but it is capped at 11.4 billion per annum, and it's capped at 4 years. I think the point was made by Senator Malahoo Fort about why are we being forced into these difficult prior actions? What is it about us that makes these prior actions necessary? Well, we know why we're being held to the fire. We're being held to the fire because the previous IMF agreement went drastically off the rails very soon after it started. And the IMF had invested significant trust in the then government and had upfronted the benefits of the program by large disbursements. So when the thing went off the rails, they began to really question whether Jamaica is serious and can be trusted. And it has taken us over a year to build back that trust and get to the point where we are now. And that's what this bill is all about. Senator Hamala Hooverford also made some points about whether targets are ever met, and that people, at least you set targets but we never make them. Well, I would simply make the point that when in 1995, when the then government was able to discontinue a borrowing relationship with the IMF, it was because the government had then passed over 10 successive IMF tests positively. And it was that effective management of the economy which allowed Jamaica to withdraw from a borrowing relationship with the IMF. Circumstances in 2010 had reached the point where we had to go back. And I'm not blaming the then government entirely for that. I think there was some mismanagement. I think the timing was late. But the world economy was in a terrible position, and Jamaica was vulnerable to exogenous shocks, and remains so. And with this, we are where we are. So, Mr. President, I think we've had a useful discussion. I think Senator Knight has adequately addressed the question of what our role is as parliamentarians. Our role is to look at the matter from the point of view of the national interest, the society as a whole. We are of the view that what is being proposed here is within the constitutional powers given to the Parliament of the land to make good laws for the good governance of the country. This is a necessary, if difficult, decision to take. There is no viable alternative that has been put forward by anybody else who's spoken today or in the lower house as to how to achieve a 7.5% of GDP primary surplus. This is the best way to do it, or the least painful way to do it. And we think it's the right way to do it in the difficult circumstances that confront the country at this time. So, Mr. President, at this point, I would ask that the bill be read a second time.